Amendment. I'm very grateful.
I just want to say this. Points have been covered, the same points. Waqf by user deletion is very serious because the statistic is that 4 out of 8 lakhs, 4 lakh out of 8 lakhs perhaps are Waqf by user. So by one stroke of pen,
I didn't want to interrupt you with this. There's an issue. You see, when we were in Delhi High Court, we were told Delhi High Court itself is built on a Waqf land.
It's all right. It's all right.
Yes.
It's all right. So that
We
is
were
claim.
also told that Oberoi Hotel is built on a Waqf land.
Well,
There are villages which are declared.
Mr. Mehta, please. We are also told Parliament is Waqf land. That doesn't mean.
I'm sorry.
I'm sorry, my
Well,
lord.
we are told
No,
Parliament
we
is
are-
also
we are
Waqf
not
land.
saying.
These
but
are imageries
don't-
created.
Just one minute. Don't misunderstand us that we are not saying that all work by users are wrongly registered, but at the same time, there's an issue and concern.
Absolutely, yes. Absolutely, yes. But what you are talking about is not individual abuse. You're not throwing the baby out with the bathwater. You are considering a per se legal abolition of the concept. Now, there's two issues arise here. Issue number one, Waqf by user, is it a novel concept created? Is it something new? Your lordships in para 1118, I think it was 1134, it was para 1118 of Ayodhya's judgment, have traced that this is a very old lineage concept. Very old. Number two question arises legally. Have you removed the basis of the judgment? Also, from Prithvi Cotton Mills through Madan Mohan Pathak, you have to do something to remove the basis. This act says that
Understood that.
it deletes. No, boss, 2RI is deleted. Just see the old 2RI. 2RI today, your lordship, in the book is a blank. In the footnote is given the original 2RI. Now that you delete. By deletion, can you remove the basis of a judgment? The judgment was not based on a Waqf by user record. It's based on was ancient material. So that's point number two. Point number three, the practicality. 4 out of 8 lakh Waqfs are supposed to be Waqfs by individually. If I go and claim Parliament to be a Waqf, your lordship will not accept it. That I can understand. But you don't say the concept is bad. That's point one. Point two is that there are two bodies. One is the collector, and one is this fellow called the designated officer. These two are the worst examples of judges in their own cause because of a series of provisions. Lordship will note that in this book, my learned friend has pointed out many of them. If you read them together, they are completely judges in their own cause. Starting with 3 IIIDA. Just note that one. The collector is defined very, very broadly. Just see that definition. 3 IIIDA. Collector is not a mere collector as the lordship thinks, fellows. Everybody, land revenue collector, deputy commissioner, or not any officer below the rank of deputy collector. Then please add to it, fellows, these other provisions which say designated officers for other things, fellows. Till they decide, this shall not be treated as Waqf property. Thirdly, they will decide.
Mr. Sipal is already flagged.
Yes. Then, fellows, the third thing is, the third issue is, this is therefore there is a subordination, whereas those provisions, my learned friend may have given you the chart, those provisions are very important. They are, just give me half a second. Sections of the Karnataka Hindu Religious Institutions Act, Dharmika Parishad Act, Religious Endowments Act, AP Charitable Act, and Sikh Gurudwara. The sections are there.
Dr. Singh,
Yes.
already. That's all, Mr.
No, just 1 minute more. 1 minute more.
For admission stage, this is
No, I'm not going to repeat, but I'm trying to, the problem is trying to sift through that, which I don't have to repeat. There is a reason why we are saying that this word contrivance is intended to make the person visit the officer for lifelong. Apart from the fact that I have to prove I'm an adherent to Islam. That one part has been argued.
5 years.
It's a cumulative condition. I have done Islam for 5 years. I go and show my faith to somebody. Thereafter, there is an additional cumulative condition of contrivance. Now, this is a delightfully vague word. It will mean I will continue going to the office and I'll be under your control
Dr. Singh,
for life.
it already argued.
For life.
So take away something.
Well, can I answer the first question? Can I answer the first question? There are 3 reasons why this should not even be considered remotely for going to the High Court. Just 3 reasons very quickly. 1, it has all India ramifications. Your lordships would never say, that there should be High Court judgments of multiplicity and diversity.
Except that argument, then a lot of matters where legislations are challenged.
No matter will come,
Always
this.
on
No,
the
kindly see. Would my lords countenance multiplicity of High Court judgments? Diverse High Court judgments?
We can direct
The
one
same-
High Court. We can direct one.
The same thing will happen, your lordship will today, number 1, this is the
But
most.
we have the
all India-
benefit then of the High Court judgment.
So let me give you all the 3 reasons. Number 1, your lordships, there is no absolute bar in 32. There is a
No,
discretionary
we are
bar.
not saying there's
Three
a bar.
conditions. Three
We are not saying
conditions.
there's a bar.
Three conditions. The first condition is Article 32. What is more, part 3 than Article 26, read with Article 25 directly. Secondly, your Lordship will have all over the country, or even your Lordship consolidates. What will be the point of spending this time, and ultimately it has reached the Supreme Court. So therefore, today, this is not that kind of a case where your Lordship sends us to the High Court.
Okay.
And there is also an issue that your Lordships should lay down the law definitely on this one. I end by one thing.
Fine.
No, but I'm saying only one thing.
Okay,
So this
now
condition-
two more.
No, 1 minute.
again, on this
Quick,
slide.
1 minute.
A quick constitutional
One
point.
minute.
One side, Mr. Hegbde.
1 minute more only.
Two sentences only.
I am saying this. If Alan also meant the same, I'm sure. Some of these pernicious provisions, they have come into effect immediately. We are seeking a stay for the reason your Lordship has said in 3 judgments: Health for Millions, then Cheshri and Rakesh Vaishnav. The only argument is a new act. Your Lordship doesn't stay the act. There's no question of staying the act.
We'll
When
come
the
to that
provisions are,
argument. We'll come to that part little later.
no, only one sentence, when there is a status quo continuing from 1923,
Dr. Seghri, why are you arguing that?
the first act came in 1913.
But I have a slightly different take on things. So I'm in 13.2, the Association for Protection of Civil Rights. Just give me a moment. I just want to point out one thing which is very, very important. Article 26, apart from 25, Article 26, let's please just see Article 26 for a moment. Mr. Sybil showed it to your Lordship, but I want to just stress one thing. Because I'm deviating a little bit from this essential religious practices or essential religious features argument. I don't think it's necessary at all, as far as the Waqf Act is concerned, to show that it is a part of the essential religious practice of Islam. Please see 26. Freedom to manage religious affairs, subject to public order, morality, and health. Every religious denomination or any section thereof shall have the right, A, to establish and maintain institutions for religious and charitable purposes. Please note the distinction drawn by the framers of the Constitution. Religious and charitable purposes. Now, charitable purposes do not have to be to answer the test of essential religious features. There can be charitable purposes which have to do with a person who believes in Islam,
Understood.
but does not have to answer. Now, contrast and to manage its own affairs in matters of religion, etc., etc. Now, in Shirur Mat, your Lordship said there will be certain secular aspects where the state can intervene.
So you're saying just read D also.
No. So and D,
Just read D.
to administer such property in accordance with law. Yes. So a law which
The law can interfere.
uh,
This accepts that law administration will be in terms of the law.
no.
Will be framed.
Lordship's right. Preface.
Understood.
No. There's just one thing. Prefaced with subject to public order, morality, and health. Those are the only three. Now, please contrast this with 25. 25 says, another provision. 25 says, subject to public order, morality, and health, and to the other provisions of this part. All persons are equally entitled, etc., etc. This is why, Manoj, 14, 19, 21, etc., etc. Other provisions of this part came in, for instance, in Reverend Stanislaus, where your Lordship were considering the Freedom of Religion Act in Orissa and Madhya Pradesh. 26 draws a complete departure from 25. This is now your Lordships have held in Sayadna and reiterated that even while referring Sayadna recently. Your Lordships have held in the Dargah Committee. Your Lordships have held in Sirur Mat. These are all constitution bench judgments. And my lords, in the state of Rajasthan versus Sajanlal Panjabat, etc. Series of judgments. Your Lordships have held that 26 bars state intervention except on provisions, except for public order, morality, and health.
That's what.
Now, therefore,
Please, my lords.
and just one last point. It's a slight repetition. What I'm saying about just one thing on 3C, that's very, very crucial because the moment a dispute is raised, it's not.
Correct, we have understood that.
It ceases to be a waqf. So,
Please, man.
no, I just want to put it in a context. Suppose there's a waqf by user for 300 years. Let's say it's a graveyard. Let's say it's a mosque. The moment somebody says, no, this is government land, you just have to say it. Then for the next 50 years, designated officer, tribunal, high court, Supreme Court, it ceases to be a waqf. So the stay is very, very important in that context.
Yes,
There's a reason in constitutional history why 26B exists, to manage its own affairs in matters of religion. Your Lordship is from Amritsar. Your Lordship may recollect that the Golden Temple in Amritsar had non-Sikh control. It required a whole Akali movement to regain control of their own Gurdwaras. So that is why the clue is to manage its own affairs. So own means necessarily an exclusion of somebody who is not your own. And that is the principle which has consistently been followed from Shirur down.
I will make one submission.
Lordship, I won't repeat.
Can't very-
Can I just take a cue from what my learner from Mr. Hegde said? I come from Kashmir.
Microphone, please.
Lord, I come from Kashmir. I'm a Kashmiri Pandit. Correct? There are temples over there. If tomorrow Muslims were to say because they are in majority, they are going to manage my temples as it is, my temples are gone. Would that be acceptable to the other side? Please juxtapose it, this proposition with the acts that have been shown. And I made something for your Lordship's convenience. No,
Not
this is
required,
not a
not
submission.
required.
I'll make one submission.
Lord, one more thing.